you tell us a little about yourself, Dean?
Sure. My name's Dean Rocco. I'm a lawyer by trade. I'm with a law firm called Wilson Elser. And while I am based in Los Angeles, California, I work with clients, including religious institutions across the country, to, on the front end, try to prevent bad things from happening and managing risk. And then when unfortunate things happen, litigating and defending those sort of lawsuits and claims.
All right, Dean. So tell us about third-party liability and how it affects the church directly.
Well, the first thing I would say is obviously churches are a place of worship. There's no denying that. But they are also businesses. Welcoming people and outside organizations into the church or sharing the facilities with the surrounding community is an integral part of engaging in ministry. But some organizations may have persons or organizations renting out office space or coming onto those facilities on a pretty routine basis. And certainly even at other times, churches are going to be inviting third parties onto their property to conduct work or perform services. So any of those sort of interactions really should be done in a way that respectfully and professionally protects the church's interests to make sure that, if any unfortunate event does occur, it doesn't threaten the future viability of the organization. And so what I would like to do today is really spend some time talking about some of the risks that are inherent in allowing third parties onto a church property and provide some concrete, relatively simple ways that an organization can manage those risks and protect the church itself.
So, Dean, what about users?
There are several types of users coming onto church properties throughout the year. Let's take a look at what they might look like, and we could even talk about some of the types of risks that are inherent in their presence on property. The first one is probably the one that sticks out the most to me, and those are the routine or regular users. A first example of this might be Boy Scouts or Girl Scouts or other youth organizations. The most obvious and catastrophic risk there is abuse of minors. Unfortunately, we've seen a slew of lawsuits against scout leaders and other youth mentors. And that risk can make its way not only back to those organizations, but also to the persons that are participating or hosting those organizations, which would obviously be the church. While we're talking about these sort of groups, I wanted to also mention something that I've encountered quite a bit, which is some of these youth organizations will ask a church to sponsor them or to charter their chapter. Understand that when you do that, you're associating yourself with and really linking yourself to that organization, and you really need to make sure that you're comfortable with the way that they're comporting themselves. And we can talk more later today about risk management and sort of due diligence, but really keeping an eye on those organizations because you're holding yourself out to the outside world as someone who's going to charter them, sponsor them, make sure that they're holding their organization out the correct way. And you want to make sure that you're doing things to ensure that that's happening. Another example of this might be sport activities or leagues. There's obviously a continuing risk there for abuse of minors, but there's also the added risks around concussions or other injuries that might be sustained while kids are playing sports. And then beyond those two groups, there's sort of the adult social organizations, book clubs, things of that nature. Probably less dramatic risks there, but those sort of individuals coming onto your premises can still suffer injuries. You can still have claims arising out of those sort of uses. So it's something else to keep an eye on.
Is there any other type of users we'd want to know about?
Of course. One of the other big categories of use that we see are the single event usage. The first example that everybody has in mind when they think about a church is a wedding. But you could also have baby showers and birthday parties. These sort of parties or celebrations are often conducted on church property. And the risk of liability during those sort of events increases exponentially when alcohol is served. So there's something to be said for those. There's also community event uses. An example of this might be a fair, sometimes with a mix of vendors or activities on site and ongoing at the same event, some of which might be riskier than others. Some of the obvious risks around these sort of uses are things like bounce houses or food vendors with cooktops or hot oil or the kettle corn guy making the kettle corn on the property, things like that. And another one that I'm starting to see more of is churches joining up with other organizations or other ministries of shared values to having a shared ministry event. In one example, we had two organizations jointly planning a fundraiser. They sold tickets, they split the proceeds. However, the event was only held on our church's property and alcohol was served. So really, the church that has that event taking place on its premises is taking on more of risk than maybe the other organization. Those sort of arrangements raise questions as to who should be held responsible if an event cancellation takes place or if something unfortunate happens to one of the visitors during the event.
So tell me about renting and how it affects the church.
Yeah, many churches end up renting office space or facilities to third parties. This might involve an after-school program or a daycare center, a counselor or a family marriage therapist, or even a nonprofit food bank or feeding ministry. Other churches find themselves renting church facilities to other ministries or buddy church groups during off hours or days where the areas for religious ceremonies are otherwise dark. We've even seen some churches renting office space to refugee organizations who are processing immigration applications, or homeless organizations which use the facilities for temporary or transitional housing. These sort of uses carry a myriad of risks onto the church property, whether it's potential injuries to the people that are visiting or people doing damage to church property when they're on the premises.
This is all great. We've been talking about users, but what does it mean for subcontractors and vendors that the church uses?
Absolutely. From time to time, a church is going to hire vendors or contractors to come onto the property and conduct work or perform services. Those sort of visitors can do damage or they can injure themselves while they're on a church property. In one instance, we saw a roofing contractor start a fire, which resulted in extensive damage to the church structure, and unfortunately the vendor didn't have sufficient insurance to cover the loss. In another example, we had employees of contractors injuring themselves on the job, and then they not only went against the contractor, but they sought workers' compensation benefits and damages through the church itself because they were on the church property when they got injured.
Now that we've talked about the users, how do we manage the risk?
Sure. Well, one of the first ways you can manage these sort of risks is conducting some due diligence when you respond to the request to use your facilities in the first place. What is your process to decide whether an organization coming onto your property shares your values or engages in conduct that reflects those values? Has the outside organization provided you any information that leaves you confident that they will comply with the applicable law or not engage in conduct that will unnecessarily risk claims against them or yourself? If you're dealing with a youth organization, do they have policies or procedures in place or training to adults, mentors, coaches, and other people that will be around those young people about abuse prevention? If they're a sports organization, have they shown you that they're part of a large organization that trains coaches or players about injury prevention or concussion protocols? If they're conducting an event, are they going to use appropriate professional and even possibly licensed vendors to prepare food or serve drinks or handle heavy equipment, building temporary tents or even structures? Ask these sorts of questions and find out some information so you can feel more comfortable about whether or not you're bringing somebody onto your property that's not going to result in liability to you and your organization.
Now that due diligence has been done on the front end, what about the back end? What due diligence should they be doing ongoing?
Sure. Well, once a church permits some form of a use, they should definitely take steps to ensure that organization is keeping up their obligations and keeping their representations about how they're going to be acting and doing so responsibly. For example, if it's appropriate, you should be asking whether or not someone from the church should be visually observing the planning or the setup or the actual day of activities of a particular third party. It might be appropriate also to have someone from the church checking in on the organization to ensure that its representatives are comporting themselves with the standards or the expectations established by the church. An example here might be observing a youth organization and seeing if children are left alone with only a single adult to supervise them.
So, Dean, what else can churches be doing?
Well, beyond engaging in some of that due diligence, such as vetting organizations or supervising their activities on your property, establishing written agreements with those parties about their activities is an important and really not as complicated as you might think step in mitigating these sort of risks. The first type of written agreement that you should really be incorporating into your practices is a facility use agreement or a lease. And I think it's probably worth talking about these depending upon the type of use for your facilities. I understand some churches may be hesitant to ask certain parties to sign agreements, particularly if they're dealing with other ministry groups or nonprofit organizations or less formal organizations who might not even be paying to use the facilities. However, any responsible group is not going to balk at signing a basic agreement, and it should raise a big red flag for your organization if some other party is refusing to sign a simple agreement or provide you proof of insurance. The first type of agreement we could talk about here is a facility use agreement. These are not intended really to be complicated documents for most circumstances, and they can be prepared or at least filled in fairly quickly without the involvement of outside lawyers. In some instances, you may have someone or some organization renting facilities or office space from you. In those situations, it's strongly recommended that you establish a written lease agreement with the tenant. Those agreements can be more involved than a simple facility use agreement, but even so, leases are generally readily available, and a simple tenancy agreement can often be documented without the involvement of outside lawyers. These sort of agreements document the expectations and obligations of the church and those parties around the use of the church facilities. On the front end, they provide a great opportunity for the church to explain its expectations around the use of the facility. Even if an organization does not have to pay for the use of the facility, they should understand that there are obligations and rules surrounding the use of your facility. And on the back end, when a claim arises, these agreements are often invaluable. The drafting of these agreements will confirm and often cause insurance to be put in place to financially back any sort of a response to a lawsuit or a claim. And it can also, these sort of agreements, make clear that liability for such claims are the responsibility of that third party and not your church.
So, Dean, we've talked about the written agreements. What should be in them?
Sure, and they can take many different forms, but I think there are some real key core terms that should be outlined in any facility use agreement or any lease agreement between yourself and a user. The first would be setting expectations. Those agreements should make clear that the church expects all uses to be in compliance with applicable law and church policies. These agreements can also make clear what the church will and will not provide in terms of the space, the equipment, or the supervision that third-party user is going to encounter. Secondly, I think they should really define the permitted use. They should not only outline the physical areas that the third party can use, but also the day and the specific times for that use. The church's potential liability would be greatly reduced if a third party went somewhere that they shouldn't have been or is on the property when they're not supposed to be there and a claim arises.
Indemnity. Can you tell me a little about that?
Sure. Let's talk about defense, indemnity, or hold harmless provisions. For many people out there, this is going to sound like complicated legalese or a particularly intimidating concept to tackle, but it's really much simpler than it sounds. Parties to an agreement can agree to shift the responsibility for defending against claims or paying for losses that arise out of their transactions. There are some legal limits to this in certain places or contexts, but a church should really try to get as much of an indemnity agreement from a third-party user as it can. A typical clause would require the third party to defend, indemnify, and hold the church harmless for any loss that arises out of their use of the facility. What does that mean? Well, if an organization holds an event on the church's premises and oversees an attendee, and that person trips and falls and hurts themselves, the church can then more squarely push the cost of defending that lawsuit and paying for any related loss to the third party or that person's insurance carrier through that sort of an indemnity provision. So rather than it falling on the church, we get to push it back to that third party who's using the facility.
So should insurance be part of these agreements as well?
Absolutely. Let's talk about insurance. When and if there is a claim, a church does not want to be facing the prospect of paying for defending a lawsuit on its own. Those costs can quickly reach tens, if not hundreds of thousands of dollars. And beyond those defense costs, a church could face potentially disastrous judgments if a claim is successful. For these reasons, any church should have insurance in place. But you want to know that those coming onto your property are insured as well. Imagine getting named in a lawsuit with a third party and maybe even having contractual indemnity that pushes the cost of defense and any judgment over to that third party. But they're broke and they don't have insurance. Guess where the plaintiff and their attorneys are going to turn? Help yourself now by making sure that the insurance is in place before someone comes onto your property and starts to use it. Now, there may be circumstances where you ultimately decide against requiring insurance. That, in my opinion, shouldn't be the norm, but there may be instances where the risk and the surrounding circumstances don't dictate it. In those instances, I would encourage people to at least put a use agreement in place that outlines the intended use of the facility and gives the church some indemnification rights for that use.
Churches and users may think that this insurance is unobtainable. What are your thoughts?
Well, that's an understandable question. A lot of churches are going to question whether certain organizations can get insurance, particularly if they're a nonprofit or a volunteer organization. However, I'd first say if they're part of a larger organization, they very well may have insurance available through their parent organization, and it's simply a matter of them asking for it. Even if that's not the case, there's a whole industry that offers lower cost, simpler to obtain options for recurring meetings or single day events. These sort of policies are much more affordable than the general liability policy or other sort of coverages that a church may have obtained to cover themselves, because they only insure a particular risk occurring on a particular day or a set of days. An individual could even reach out to the insurance board and get some additional information from them about their TULIP program, which is this type of insurance program.
So Dean, do you have any additional thoughts surrounding best practices and insurance?
Sure. I guess the last thing that I would say is when you do require insurance for a use, you should ensure, or you should insist that the third party names the church as an additional insured on their own policy. And you can also request proof of this insurance through the production of a certificate of insurance. This may sound formal, but it is in fact a very routine practice, and it's something that's very easy for any insured organization to do. The third party can and should be able to provide this to you before they use your space. And you should maintain a copy of that certificate in your possession so that, again, if a claim arises, you know who to go to get that sort of coverage for the claim.
So now that we've talked about the users and the risk, what about the subcontractors that come on the premises that were invited by the church? How does that affect them?
I think that's an important question, and we really should talk a moment about that. So, we've looked at the agreements with the persons that are requesting to come onto a church's property, as opposed to the other way around. When a church has a vendor or a contractor coming onto the property to perform services, a lot of the same types of considerations that we've been talking about should be in play for any church. A written agreement should be put in place that establishes the scope of the relationship, a scope of work, as it were. And beyond establishing what the third party is coming onto the property to do and what you're going to pay for it, it should also try to include other provisions that protect the church's interests. Where you can, I would insist that it reflects that the third party will act within the law and in a workmanlike manner. Where appropriate, it should reflect the fact that the vendor will maintain any required licensing or certifications or bonding. It should definitely confirm that the contractor's employees are going to remain the employees of the contractor and not be considered jointly employed by that contractor and the church. And along those lines, it should insist that the vendor will maintain their own workers' compensation insurance for any worker that's coming onto your property. And then finally, I would say that any church should push to try to get indemnity obligations with that contractor in that agreement and insist that appropriate levels of insurance are in place. You can request to be added as an additional insured on larger projects, and you can ask for certificates of insurance before work starts. Just like you wouldn't rent your facility to a third party who refuses to sign a facility use agreement or provide you proof of insurance, you definitely should not be doing business with a vendor who won't put their commitments to you in writing or show you proof that they have a proper license or show you proof that they have insurance. Oftentimes, that might be the cheaper bid, but you'll end up paying for it in the long run if a problem arises.
So, Dean, do you have any concluding thoughts on this whole thing that we just talked about?
Sure. I guess just to sort of summarize it, I appreciate that a lot of people that are at the leadership of these churches and religious organizations view their purpose as a place of worship and a place of ministry, and being a place of business may properly take a second chair to that. But it's really important to give thought to the people that are coming onto your property, the people that you're inviting onto your property, and establishing some arm's length arrangements between those folks and put some of the expectations around the use into writing. And when you do that, do some things to really protect your organization, your church, so that if an unfortunate situation arises, that the church doesn't become the proverbial deep pocket that everybody goes to, and that there are indemnity provisions, insurance, things in place that can push some of that liability away from the church and allow the third party to be the one responsible for responding to those sort of claims. Doing so shouldn't feel awkward. It's something that's done in everyday business. And as I mentioned a couple times during our interview today, if you're coming across organizations or vendors that don't want to engage in that sort of an exchange, it's probably a red flag that that's not an organization or a business that you should be involved with.
Thank you, Dean, for all the great insight and advice. I'm Jennifer Perry, Assistant Vice President of United Church Insurance Services, the internal agency at Insurance Board. I wanted to take a few minutes and introduce you to a product we offer and refer to as TULIP. TULIP is an acronym for Tenants and Users Liability Insurance Program, a liability insurance policy a third party can obtain specifically for use of your church premises for one-time or recurring events. While offering church facilities to the community may be part of your ministry, all users, whether a member hosting a one-time event or a long-term tenant, need to be treated at arm's length. While the respective missions may be compatible with those of your organization, their guests, clients, and employees may view your church or organization as any other landlord. When the third party does not have their own insurance, TULIP allows the tenant or user to purchase a low-cost general liability product to cover their liability related to the utilization of the church premises, protecting the entity as well as protecting the church by providing an extra layer of insurance and including the church as an additional insured. Upon approval of a short application and premium payment, Insurance Board is able to offer TULIP coverage. If your church has interest or need for TULIP, please contact your agent for more details or visit our website at www.insuranceboard.org.